Alex here with part 9 of the My Docket series on child custody and visitation. As with all my previous videos, I would like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. The two things that I'd like to glaze over really quickly are, number one, please don't feel bad for me because I am not in this situation right now. In fact, this case, my case, is completely and totally closed. It cannot be reopened because my ex's parental rights have been terminated. Number two, the purpose of the series is to provide the viewers with one big gigantic example from beginning to end of my 8 years long child custody dispute. And it's going to be in chronological order, and that being said, we left off in part 8 with me having gone to my first hearing where I would address a judge directly, face-to-face, and in this case it was a domestic master. You can watch my video on domestic masters if you want to know how to distinguish the two. But what I'm trying to say is this is the first time I have interacted with a judge, the first time I have gone into a courtroom and provided testimony and oral arguments in support of whatever it was I was requesting. In this specific situation, I was requesting to have the order of protection dissolved. And this presents a somewhat unique situation because ordinarily you will be waiting several weeks, sometimes even months, for a final written order to come out following a hearing. But because of the statutes enacted by the legislature with regards to orders of protection, the entry of the order of protection, which in this case is the final written order, happens immediately on the same day of the actual hearing. So there isn't really a gap between part 8 and this video right now, part 9, for me to describe my mindset between the last video and this video. This video is going to pick up right where we left off in part 8, and it's going to really only involve a number of housekeeping papers, ancillary documents that were filed that don't really deserve or need their own dedicated My Docket video, and the extended order of protection itself. So let's take a look. Here we have the extended protection order. This is a form order, which means that the order wasn't prepared custom by the court. Rather, it's one of those mass-produced documents that has a bunch of fill-in-the-blanks, initial areas, checkboxes, and so more of this order isn't going to be as relevant to the case as a custom order would be, so do expect me to skip over those portions. Also, this order is mostly identical to the one covered in part 3. And that is the temporary protection order. So when I see an area of this order that I've already done analysis on in part 3 of the My Docket series, I'm just going to skip over it and refer my viewers to part 3. Of course, if you've been watching the series in chronological order, you would have already seen it, and so you would kind of just be able to follow along as to those portions that I've skipped over, because you will hopefully recall what I described with regards to those portions of this a protection order. Scrolling down, you'll see here that it issued on the same day as the hearing. As far as I know, the judges do not have any discretion here. As far as I know, it is mandatory for this order to be entered on the day of the hearing. Maybe it's something like within 24 hours. And with the expiration date, again, pretty obvious. With this, you are given the date as to, or the final day, that you are bound to the provisions of this order. This specific protection order was only extended for 3 months. This is something that the judge went into in detail in part 8 of the My Docket series. So if you'd like to learn more as to why it was only extended for 3 months, definitely just take a look at part 8 and that'll jog your memory. The boilerplate here is just warning you that if you do not comply with this order, you are committing a crime and you can be arrested. That is extraordinary. Usually when you violate a court order, you can be subjected to contempt of court, but it usually isn't also a criminal act. In this situation, with these orders of protection, it is. I do go over this a little bit more in part 3 of the My Docket series, so I'm going to just move on. The first paragraph here is pretty typical in any court order that is entered following a hearing. Almost universally, the first paragraph is going to discuss the parties that were present, the counsel that were representing the parties, or if one party was an improper person representing themselves, it'll designate as such. And typically there will be some boilerplate language as to the court having heard the testimony of the witnesses and reviewed the evidence, etc., etc. And the jurisdictional, I guess you could call it, the jurisdictional boilerplate will be in there too. That'll be the portion of the order that mentions that the court verified it had jurisdiction over the parties. This portion of the order here describes the locations that I would be prohibited from being anywhere near, and I went over this in more detail in part 3. These are identical to what I discussed in part 3. Nothing here has changed. Okay, this bold bold language is the visitation. You could call it temporary visitation, but it's more so interim. It's more so to just hold me over until I get in front of the actual child custody judge, the district judge that will be presiding over the child custody action that I instituted in part 1 of the My Docket series. But this judge is just, or this domestic master is just going to make sure that I have some kind of meaningful visitation with my son, pending that gap in time between the day that this order of protection was entered and the day that I actually appear in front of the district judge. These details were all discussed in part 8 of the My Docket series. At the hearing, the judge describes that I'm going to have telephone contact, supervised visits very temporarily for like 2 weeks. After that, it also describes who will be supervising those visits, and it also describes when what the visitation schedule will be after the supervised visits end. It also describes that I'm required to enroll and attend one of these domestic violence education classes. I don't recall taking this class, but I assume I did. There's no reason as to why I would have violated the court's order, and it was probably just something that I couldn't remember because maybe it was just like a one-day thing for a couple of hours. By the way, attending these classes is not an admission of guilt, and it wasn't used against me later on. In fact, I was given physical custody a few months later, so the mere attendance of one of these classes isn't going to have an impact on your actual child custody case. The last provision mentions that my motion to dissolve was denied, which makes sense. If it wasn't denied, this order wouldn't have been entered. This is the order to law enforcement, which I covered in part 3. I'm just going to glaze over that. Okay, this language here is letting you know how you can object to the recommendation for order. I'm not going to cover this process here because I've already done it in another video. If you want to learn more as to how you can object to a recommendation for order, watch the video Objections to Master's Recommendations. That's what it's titled. I covered the notice to all parties in part 3 of the My Docket series. I covered the notices to the adverse party also in part 3 to the My Docket series. This order and notice I also covered in part 3, but I'm going to actually, I guess you could say, make an addendum here. I assumed that this was part of the protection order, and I assumed that this district judge signed the protection order. But I'm wrong, or I was wrong with respect to what I said in part 3. What this is it's a single piece of paper that was signed by a district judge that the domestic masters are required to attach to the back of their protection orders. So this district judge hasn't actually participated in this action. She hasn't reviewed the order of protection. She just prepared this piece of paper, who knows how many months or even years prior to when this action was instituted. And the domestic master in this case, who actually signed this order of protection, she just stapled this piece of paper to the back of her order. So I wanted to clarify that now in case anyone in part 3 realized that that was a mistake, or even if not, just clarifying now that you may have situations in your state or in your case where you think a certain judge signed an order or participated in your proceedings, but in reality, it's just some piece of paper that they had to staple to the back of an order. So just something to keep an eye out for, for my viewers. Here we have the minutes. The minutes are, there's not a whole lot you can do with this piece of paper. A lot of people try to use the minutes, like when they file an appeal, or they'll try to use the minutes to hold their ex in contempt of court, but the minutes don't constitute an order. In fact, there are mentions in the Supreme Court of Nevada that you can't use the minutes for anything, that they're just ineffective for any purpose. They're as ineffective as a judge's oral pronouncements from the bench. This is something I talk about a little bit more in the video Proposed Orders. Definitely watch that video if you want to learn a little bit more as to what I'm talking about. But the minutes, it's just an assistant who was sitting by the judge who was keeping track of everything that was said, and they just memorialize what occurred at the hearing. And it has no binding effect on anyone. It's just one of those things that is attached to the docket or included in the docket to sort of jog somebody's memory if they're interested in finding out what occurred at a hearing, but they don't have transcripts, or they don't want to pay for transcripts, or they don't want to watch the video. There is another thing that I want to mention. Minutes are different from minute orders, and I may cover that in another video. I'm not going to cover that here. Also, a lot of people will use the minutes when they as a reference to something that they're trying to back up when they're communicating with an attorney or with their ex. And what I mean by that is they'll use it as a reference typically when the hearing has occurred but no final written order has been entered yet. So there's this gap of time, sometimes it's weeks, sometimes it's even months, between when a hearing occurred and when a final order is entered. And sometimes in that gap of time, some kind of shenanigan is pulled, and there needs to be reference to what occurred at a hearing. And so the only thing really available at that time is the minutes. And so sometimes people use the minutes for that purpose. I'm not really going to cover this document because all it does is reiterate what occurred in Part 8 and what the judge described now in Part 9 in the extended order of protection. So because it would just be superfluous, I'm going to skip over it, but of course it'll be available for download if somebody wants to click on the link down in the description below. They can download it. Moving on to the notice of appearance. This is a document that has, I think this was filed before the hearing. Yeah, it was. This is the notice of appearance. This is the document that my ex's attorney files in the action to let the court know that my ex is no longer representing herself, that this attorney, Kathrine Berning, is appearing on her behalf, and that all further papers and pleadings in the matter be sent to her at the address described. A notice of appearance is a very common piece of paper filed in a court case. It just lets the parties and the judge know that an attorney is going to be appearing on behalf of one of the litigants. Let me see where she sent that to. Okay, this is a notice of appearance that was sent to the wrong address. And so I know that in this video, I don't know if this was an issue actually in this video. I know that I described this exact problem in my, I can't remember which video it was, but it was the notice of appearance that was filed in my child custody action. It was sent to the wrong address, and her attorney filed another notice of appearance with a corrected address. In this case, it doesn't appear that she did that, but that's just a note that I wanted to make here. This is just the boilerplate affirmance, or sorry, affirmation. And affirmance is something else entirely. This is the affirmation. It's surprising that the attorney is using these. These are like self-help forms. They usually include the affirmation as a single sentence to whatever it is that they're filing. Usually, I've mentioned this before a few times, but usually it'll be included like right around here. So it's odd that she's using those boilerplate forms, those blank forms, but that's what she wants to use. This is the notice, or this is the affidavit of service. This is probably one of the deputies serving one of the orders on us. This is Deputy Roxanne Silver serving upon me in order for hearing to extend, modify, or dissolve the protection order. I'm surprised that they served me personally, because it even has the time here, 3:46 p.m. It just seems like a whole lot of work to just give somebody an order that could be mailed to them. There may be a statute or a court rule that I'm not aware of that requires these documents to continue to be served by deputies. But, wow, it's just a lot of work for the state to keep up on. This is probably the order that followed the filing of my motion to dissolve that was served, or the order for hearing that followed the filing of my motion that was served both on me and, as we take a look at the next form, my ex. This is the affidavit of service indicating that a deputy served my ex with those same documents. So, I mean, really nothing to look at, nothing fancy. The location, I wonder where it was, if it was served on her. Oh, confidential. So it was served on her personally. This is before her attorney filed a notice of appearance, and so the deputy would have had to serve her. If her attorney had appeared prior, the deputy would have just served her attorney instead. Going into the aftermath, this judge has disposed of both pending motions and the initial pleading that my ex filed, which was the application for order of protection, with her entry of the extended order of protection. The extended order of protection grants in part my ex's motion to extend. It gives her 3 additional months of behavioral restrictions on me, the first being that I can't go near certain locations, and the second being that my communications to her have to be on topics involving our son. The motion to dissolve that I filed was denied. The initial pleading that my ex filed, which was the application, contained a few other things that she had been requesting, including temporary custody and visitation. The court gave her temporary primary physical and sole legal custody, which was to remain in effect only until we were able to get in front of the presiding district judge over the child custody proceedings that I instituted in part 1 of the series. The visitation was 2-tier. The first tier lasted for 2 weeks, and that was supervised visits, and the second tier was unsupervised visits, which was to last in the interim, which was between the end of this action, which is the order of protection action, and the first time that I made contact with the district judge in the other action, which is the child custody action. So the financials aren't going to really change much. My ex and I did not incur any costs, and I didn't have an attorney, but my ex did. She would have only incurred attorney fees for her attorney reviewing the entry of the court's order of protection and reviewing the minutes, and she probably would have charged to file the notice of appearance as well. But I'm thinking that all 3, reviewing those 2 entries by the court and filing the notice of appearance, would have probably been billed to her at around a half hour. Again, I'm not really trying to inflate these numbers, so I'm kind of erring on the conservative side. And so going with the rate of $250, which we established several videos ago, that comes to attorney fees in the amount of $125. So if anyone has any questions or comments, definitely post them down in the comments below, and I'll get back to you as I read them, and I will see you guys next time.